Thank you, Matt. This is Larry Schnapf. I'm going to talk to you now about some of the issues associated with affordable housing with the Brownfield program. The Brownfield program has been an extraordinary tool for affordable housing projects in New York State and in particular New York City. There was a study done last year by NYU, and the Brownfield program in New York City contributed to 19,000 units of housing, of which 6,400 were affordable. The tax credits, the tangible property tax credits, are a real powerful tool because they both reward the developer, but it also serves as equity. So, for example, agencies and tax credit investors could look towards the tax credits as part of the equitable or equity contribution of a developer. So it basically unlocks value and creates collateral that is very useful for these projects, which, of course, operate on very narrow margins. Now, there are some complications with affordable housing projects. Before we get to the changes, I want to give you a little more background. So oftentimes, affordable housing projects are going to be built over a course of time. They'll have multiple buildings oftentimes, sometimes with different ownership. And there's only one certificate of completion, though, that is issued per site. So you may have multiple affordable housing projects on a brownfield site, but there's only one certificate of completion, which the significance of that is what Matt just talked about. The total site prep costs are going to be used to calculate what the cap is for the tangible property tax credit. So the first building that goes into service that gets its T of O or C of O and then is eligible to claim the tax credit might consume all of the tax credits that are available for that total project. So that's one of the things that is complicated with brownfield projects on affordable housing sites. In the early days, the housing authorities allowed the applicant to claim all the tax credits that were available. So if they were going to get $1 million worth of tangible property tax credit, the developer would get that. At some point, there was a change in policy, and some of the agencies, particularly in New York City, but then now also going upstate, decided that they wanted, since they're subsidizing these projects, that they wanted some return on the tax credit in order to help make their program sustainable. So they started wanting to have a percentage of the tax credit that would normally flow to the developer. Most recently, the Housing Authority in New York City has decided that it wanted, instead of the Housing Authority acquiring the tax credit, it wanted the tax credit to be acquired by the tax credit investor. That's usually done by way of acquiring interests in the entity that is eligible for the tax credits. And the problem with that is that the tax credit investor is probably going to only pay a percentage of the full amount, like they do with the low-income housing tax credits. So that is a less lucrative arrangement for the developers who are taking the risk. Whether that policy stays in effect, we don't know. This is one of the number of policy changes that have occurred that have actually been detrimental to this incredible synergy between brownfields and affordable housing in New York. So let me go now to the process for becoming an affordable housing project. So again, upstate, this is not an issue for tangible property because projects, brownfield sites out of New York City as of right are entitled to the tangible property tax credits. It's only when you're in New York City that you have to qualify for one of the gates, now 6. And one of the 6 gates, as Matt explained, was affordable housing. And the way that works is once the developer enters into a regulatory or binding agreement with the housing authority, then the housing authority will issue a regulatory agreement, and that becomes the document that allows DEC to say, yes, this is an affordable housing project. Most of the time, this regulatory agreement has not yet been executed by the time the applicant is entering the program. That regulatory agreement usually comes at construction loan financing. So what the usual process is that the applicant applies to the Brownfield program. It initially is accepted without the benefit of being eligible for any of the tangible property tax credits. At some point during the cleanup process and before the COC is issued, it then obtains the regulatory agreement from the housing authority. At that point, then the applicant would submit an amendment to the Brownfield Cleanup Agreement, which would then clarify that the project now is eligible for the affordable housing tangible property tax credit. All the costs incurred under the site prep are good for that determination. It's just a timing issue about you can't get you can't qualify as an affordable housing project until you get the regulatory agreement. And then the Brownfield Cleanup Agreement is amended, and that has to be done before the certificate of completion is issued. One of the problems that we got in the last couple of months before the amendments went into effect is that some of the regulatory housing authorities decided that they no longer wanted to give regulatory agreements at the construction loan, but they wanted to give it at the time that the TOC is issued, which would be post COC. And that created a problem because affordable housing projects, if they don't get the regulatory agreement before the COC, the DEC does not amend COCs. So once your COC is issued, if you got your regulatory agreement, there's no way to amend the certificate of completion to show that the site is eligible for tangible property under the affordable housing gate. And it's the COC, which is the document that the Department of Taxation and Finance will use to determine if you're eligible or not. So this has been a problem. During the legislative process, we tried to get this problem fixed through a variety of ways, one of which would have been to allow the regulatory agreement to be issued afterwards, and that although the DEC wouldn't actually have to amend the COC, the tax department would understand this. Another one was to have some arrangement, maybe get the housing authority to agree to do a regulatory agreement even before the COC is issued. We tried a whole bunch of ideas. None of them worked. The legislature just got caught up in another affordable housing tax program known as the 421A, which expired. There was a perception that these affordable housing projects were too expensive and that the taxpayers were not getting a number of truly affordable housing projects for the tax credits they were getting. And so this kind of got tied up into that, and there was an unwillingness to work. So we're left now with the DEC and the state and city housing authorities are supposed to work something out on the timing issue in terms of how we can go forward with this regulatory agreement. Maybe they'll come up with some understanding. We don't know. But right now, this can be a problem for affordable housing projects. The other issue that occurred was that the definition of affordable housing was amended so that there is now an ability for DEC to determine that some of the tax benefits that would otherwise be eligible under the affordable housing gate might not be. And again, this was probably directed at the high-end affordable housing rental projects. So for example, in some areas of New York City, $130,000 would make a person earning $130,000 could qualify for affordable housing based on the median income. So we think that there's a possibility that you might otherwise qualify. Let's say there's $1 million or $10 million worth of affordable housing tangible property tax credits. But if a percentage of those are for sites above a certain AMI, the DEC might say those units are not eligible for the affordable housing gate for the tangible property. So we don't know how this is going to play out. We tried to fix this. The legislature was just not interested in clarifying this. In fact, in some respects, not only not fixing the timing issue, but having the DEC have this ability to, on its own, decide that some portions of an affordable housing project are not eligible, actually is a step backwards. And it's just mind-boggling because of the value that the Brownfield program has brought to affordable housing. One of the takeaways from this is that when you do have, oftentimes, there's going to be an environmental lawyer on a project working on the Brownfield piece, and then a housing attorney that's working on the housing qualification process. It's important for both of them to talk, and it's important for the housing attorney to try to get clarity on this regulatory agreement as to when is it going to be issued at time of construction loan, which is usually the money it's used to help do the cleanup, or is it going to be at TOC? I mean, if that's where the agency's going, is going to have to be negotiation to try to get it before the COC so that the project would be able to qualify. Because again, without this tangible property tax credit, some of these affordable housing projects just don't work. The tax credit is invaluable, both in terms of the amount of money it throws into the project, and it's the fact that the developer can use that as equity up front and not have to contribute their own funds and devote those funds to cleanup. Let's see. So another related issue that was introduced into the amendments is we now have an application fee for brownfield sites. Before, there was no application fee. Now, many states have application fees for their brownfield programs. And so this originated as DEC was complaining that their resources are strained by the brownfield program and is taking resources away from the Superfund program, which, of course, there are some questions about that statement, because a lot of sites that would be going in the Superfund program are not being listed but being enrolled in the brownfield program. Anyway, there was proposal in order to help the DEC, that the application fees would be directed toward the brownfield program so that more staff could be hired. Well, they took a minimal suggestion of maybe $5,000 and turned it into $50,000. So this is an application fee that has to be paid. It's going to be paid during the application process. We still don't have regulations out or guidance out officially as to how this process is supposed to work. One thing is, because this fee is going to be incurred before the Brownfield Cleanup Agreement is executed, this $50,000 will not go towards the tax credits. The costs have to be incurred by the party on the COC after the COC is issued. So this is a non-tax credit eligible fee. There is, however, a process for waivers. And again, the agency has not, they're going to be developing regulations for that. They amended the Brownfield Cleanup application to provide for some guidance, and I'm going to show you that here. So there's a new section 8 to the application, and it says, upon submission of an executed agreement, the requester is required to pay a fee. They may pay a fee based on demonstration of financial hardship, and then there's instructions to how to do that. There is another iteration that is suggesting some factors. Let me go back to, so essentially, the factors are things such as so these are factors that the DEC said they're going to consider. Now, they understand that this is an iterative process and that they don't know what kind of factors applicants are going to ask for. So they came up with a couple of factors. They're not exclusive. And it doesn't mean that you can't try for others. But the application fee, application for the waiver, things such as the payment of the fee would prevent the applicant from completing the remedial action or make the project financially unfeasible. Another factor which was really scary was that whether the applicant is waiving its tax credits. I clarified with the department, they're not expecting that as a requirement. They just want information. I think they're going to probably use what they use, the kind of approach we use in Superfund, where you try to make an ability to pay argument to try to settle a claim for cost recovery. If they follow that approach, that means you're going to have to file tax returns, copies of your tax returns, to show that this $50,000 fee is not is really going to make the project unaffordable. A lot of people are not going to want to submit their tax credits, their tax returns. And indeed, there's been 16 applications that have been submitted since the amendments went into effect. And 8 of those are from the New York City area, 5 are from the Buffalo area, and 3 are from the Hudson County area, Hudson Valley River area. None of them have asked for the waiver yet. So now it's possible they may ask for it after they're entered into after they're accepted, and during the period when they have to execute the BCA. But as of now, no one has requested that, and as you can see, I think part of it is that they don't want to have to provide the information that DEC is may want to ask for. Dave, I think this slide is this slide? No, so the underutilized gate was an issue that wasn't addressed. As Matt mentioned, this is one of the gates to get into qualify for the tangible property tax credit, and it's really hard to qualify for this gate. I think only 2 sites have been accepted since this gate went into effect in 2015. The DEC adopted a definition that is really unmoored to any reasonable view of what underutilized means. It's actually a forward-looking definition. It's not based on what the current use is, but what the future use is going to be. And you need to get also some certification from the New York City that, as Matt said, that the financing would not happen without assistance. There have been a couple of projects that have been able to meet this. They've essentially had to do a survey of other developers in the area to show what the market requires in order to finance a project. So it's a cumbersome process, and it's very relatively low percentage of success. And we wanted to try to get this included. The problem also is that a lot of the end zone sites, we didn't really know what that meant or how that was going to work during when the amendments were first completed in 2015. And this underutilized is meant to sort of fill the gap for projects that are meritorious, but maybe they're a block away from an end zone site or 2 blocks away, that don't really fit within the corners of the other gates. Well, I'll just want to reconfirm what Matt said, that the department is really scrutinizing applications for levels of contamination. There were recently 3 applications denied because the department felt there wasn't sufficient contamination to be eligible for the Brownfield program. So you need to have, again, consistent exceedances of the restricted residential levels across the site. If you have two tax lots in the project, both tax lots have to have this. If you have one and the other one doesn't have it, that lot that doesn't have exceedances will not be accepted into the program. This does pose problems in transactions where perhaps a lender wants a regulatory sign-off and the site is not eligible for the Brownfield program. How do you get the regulatory sign-off? Well, if you're in New York City, at least there is the Mayor's Office of Environmental Remediation has a voluntary cleanup program that does have much lower standards for eligibility, and even moderately contaminated sites can get in. You can get a notice of completion and get your regulatory sign-off. If you're outside, or if otherwise, the other possibility is there could be what we call P orders, which are enforcement orders, where you do a cleanup for sites that would be potentially Superfund sites. That's another option to get regulatory sign-off. And in some cases, the lender might accept just a soil management plan. In other words, when you apply for the program, make sure you have enough soil samples, and particularly if you're going to be on a tight time frame, because if you go through the process of the application, which is 30 days completion, and then a 30-day public comment period, you've lost maybe 60 days, and then you learn that the site does not have sufficient contamination. They give you an opportunity to go out and do more sampling. So you really want to get a consultant that knows the program, a lawyer knows the program. You get your preliminary date and say, is this enough based on experience? Dave, I think that's all I have on that point.
Okay, I guess I'll leave you, or we will leave you with one final practice pointer, and that is a number of the issues that were not resolved in the Brownfield Cleanup Program amendments were not resolved on the basis that DEC had promulgated some draft regulations under Part 375 of 6 New York Code. And those draft regulations are still in process. They have been proposed. There's been a very extensive series of comments. These are actually, in many cases, issues that are really quite important in the implementation of the program, including some of the affordable housing issues that Larry mentioned, including some of the soil vapor issues that we didn't get around to mentioning. So any of you that have sites in the program or are thinking of putting sites into the program should pay attention to the Part 375 regulations. The comment period is closed, but it may well be that the comments were so extensive they'll have to re-promulgate the regulations, in which case there might be another comment period. In any event, those are things to keep your eyes on if you're interested in this program or in doing brownfield remediation in New York State. So with that, I think we'll close the program. Thank you all for your attention, and we hope it's been helpful to you. I think the program materials have our contact information in case you would like to reach out to any of us for further information or guidance on any of these points.